Okay, we are ready to start our afternoon panel. Our afternoon panels will be dedicated to solutions. We have talked about the causes of the phenomenon, the shout down cancellation phenomenon. We've talked about the effects that it might have. And of course, these things bleed into each other. But the primary focus this afternoon will be on solutions. The first panel will be dedicated primarily to solutions in the law schools, and the second to solutions that the profession, the judiciary, and the practitioners at large might have. So I'm going to introduce the first panel. For you all, another distinguished group. Professor Tom Ginsburg of the University of Chicago Law School focuses on comparative and international law from an interdisciplinary perspective. He holds BA, JD, and PhD degrees from the University of California at Berkeley. His latest book is Democracies and International Law, and is the winner of 2 Best Book Prizes, and his prior books include How to Save a Constitutional Democracy, written with Aziz Hook, I hope I said that right, which won the Best Book Award from the International Society of Constitutional Law, the Judicial Review in New Democracies, which won the C. Herman Pritchett Award from the American Political Science Association, The Endurance of National Constitutions with Zachary Elkins and James Melton, which also won a Best Book Prize from the APSA, and Judicial Reputation with Nuno Garupa in 2015. So we thank him for being here today. Professor Nadine Strossen is the John Marshall Harlan Junior Professor Emerita at New York Law School and past National President of the American Civil Liberties Union. She is a senior fellow with the Fire Foundation and a leading expert and frequent speaker, media commentator on constitutional law and civil liberties. Professor Strossen has testified before Congress on multiple occasions. She serves on the advisory boards of the ACLU, Academic Freedom Alliance, Heterodox Academy, National Coalition Against Censorship, and the University of Austin. She is author of Hate, Why We Should Resist It, with Free Speech, Not Censorship, and this is what it looks like, Free Speech, What Everyone Needs to Know, forthcoming in 2023, but since it's November, it is now out. Of course, we hope that absolutely from Oxford University Press, another a great contribution from her. Finally, joining us on Zoom is Ilya Shapiro, who is a senior fellow and director of constitutional studies at the Manhattan Institute. Previously, he was executive director and senior lecturer at Georgetown Center for the Constitution, and before that, a vice president of the Cato Institute and director of Cato's Robert A. Levy Center for Constitutional Studies. Mr. Shapiro is author of Canceling Justice, The Illiberal Takeover of Legal Education, which is forthcoming in 2024. If I had a cover of his book, I would show it to you too, but go out and get that as well. And Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, which came out in 2020, and co-author of Religious Liberties for Corporations in 2014. He is the editor of 11 volumes of the Cato Supreme Court Review and has testified many times before Congress and state legislatures, and has filed more than 500 amicus Friends of the Court briefs in the Supreme Court. Thank you to all of them. Our moderator is my co-coordinator of this event, Marshall Breger. He is ordinary professor of law here at the Catholic University of America Columbus School of Law. From 93 to 95, he was a senior fellow at the Heritage Foundation, and during the George Bush administration, he served as Solicitor of Labor, the chief lawyer of the Labor Department with a staff of over 800. During 1992, by presidential designation, he served concurrently as Acting Assistant Secretary for Labor Management Standards. From 85 to 91, he was chairman of the Administrative Conference of the United States, an independent federal agency. And 87 to 89, he also served as alternate delegate of the U.S. to the UN Human Rights Commission in Geneva. From 82 to 84, he served as special assistant to President Reagan and his liaison to the Jewish community. In fall of 2002, Professor Breger was Lady Davis Visiting Professor of Law at the Hebrew University of Jerusalem. In the fall of 2003, he was Distinguished Fulbright Lecturer in the Philippines. So thank you to Marshall for moderating the panel. I'll turn it over to him now.
Well, thank you very much. And thank you, Ilya, for being with us when given your other unexpected duties. This is a solutions panel, so we have a big responsibility. I'd hope that we can focus on solutions that are law school specific, recognizing that law schools are part of a wider ecosystem, the university, and in fact, the broader culture. So I'm hoping that in your remarks, you could think perhaps of responses to at least some of the following questions. What proposals do you see might work for law schools specifically? What are the responsibility of administrators to make clear what is licit and what is illicit? Maybe even make clear beforehand so they don't get sucked into the problem. Thirdly, is there a responsibility of law schools to protect students who engage in illicit, unpopular speech? I'm referring to doxing, I won't hire you, et cetera, et cetera. And then what right do white supremacists, teachers, and students have in a law school? We'll start with Keith. No, we'll start with Nadine.
Yeah. Okay, those questions are wonderful. I'm not going to be able to do justice to all of them, or probably even any single one in the allotted time. If I may, and I asked Marshall about this in advance, I would like to start by building on the excellent presentations that we've had so far, because even though they were not expressly focusing on solutions, clearly the problems that they diagnosed give rise to corresponding solutions, some of which are not unique to law schools. They also pertain to other aspects of the university, but certainly are important and perhaps especially important at law school. So let me just briefly go over those. So, there was such a generative power from the prior speakers. And I've just written down ideas in the order in which they emerged from points that various speakers were making. Jonathan Zimmerman talked about teaching and the focus on teaching. And I must admit, until he answered the question, I had the question in my own mind, what does this have to do with promoting free speech, including at law schools? He answered that expressly, but I want to remind all of us, he said, unless our law schools, for example, take seriously the responsibility for the moral development of their students, and create incentives that recognize that this is an important responsibility beyond research and scholarship, we're going to continue to have students who do not consider teaching and academic freedom to be important. Related to that, both Greg Lukianoff and Jonathan Zimmerman suggested that if we really care about students' mental health, and I have no doubt, I give everybody the benefit of the doubt, we have to get beyond what we think as amateurs is going to be helpful to them and listen to the experts and understand that protecting them, quote unquote, from speech that is emotionally traumatizing or potentially emotionally traumatizing, because I agree with Randy Kennedy that we can overcome that potential trauma. We're in fact going to be undermining their mental health. So let's, stop being amateur about that. This one is so obvious, requiring that the First Amendment be taught. Jonathan Zimmerman was shocked that it's not a requirement at most law schools now in constitutional law courses. I think it should be a requirement at every level of education, starting with K through 12. Just the way we used to require basic civics education, and I could not agree more that First Amendment freedoms are the most fundamental bedrock for exercising our civic responsibilities at every level. Becomes especially important in law school. Next, that we should start inculcating students in the importance of not only freedom of speech, but to pick up on a point that Deborah made, the responsibility of listening and of civility and civil discourse. That can't wait for the course on point. It has to be part of orientation. And I would say even earlier, every communication that the educational institution has with a student or a potential student, including the recruitment materials, should stress the importance so that students understand that this is an essential aspect of the culture and of the education that is going to be your benefit, but it's also your responsibility to participate in. And if that doesn't sound appealing to you, then go somewhere else where you're going to be protected against that. We talked a lot about tenure. I think it's a very, very important topic because tenure is something that was endorsed by the AAUP back in 1915, not as an end in and of itself, but as a means to the end of academic freedom. It was seen as a necessary precondition for meaningful academic freedom. And I think we have to do a serious cost-benefit analysis. I think there's a lot of evidence, much of the anecdotal evidence, that tenure is not, in fact, protecting academic freedom, both because it doesn't protect professors against punitive, retaliatory, even dismissals for controversial but constitutionally protected speech. Secondly, because it doesn't substitute for the courage that is necessary if people are not going to, tenured professors are not going to engage in rampant self-censorship. But then we, in addition to looking at, and then there are also costs of tenure that in terms of academic freedom, which we don't usually take into account. I think one of those costs was alluded to by one of the prior speakers, that it creates a system that encourages, somewhat paradoxically, encourages conformity on the part of those who are seeking A, tenure track job, B, promotion along the tenure track. The power is held by those who are already in their departments, and that may be one of the explanations as to why we see increasing lack of heterodoxy in various departments, and certainly including law schools. So if the goal is protecting academic freedom, maybe tenure is not enough. Maybe we should even get rid of it, as the University of Austin is considering, not at all committed to that position. But I think we have to be very open-minded in examining that. Bartlett talked about students not daring to, or perhaps just not even being interested in, who knows what their motivation is, expressing certain positions that are critical of what the dominant orthodoxy might be. Throughout my teaching career, and I think this is especially necessary in a law school, but again, I don't see why it couldn't be required in college, or for that matter, K through 12 as well. That is, and here's a mantra, anybody who's been my student could repeat it in their sleep, because I say it so many times in writing and orally. In order to pass this class, let alone get a good grade, you must be able to understand, articulate, and advocate every plausible position on every issue. And that means, when I say plausible, that means you can't just have a conclusion, right? Nothing conclusory that's unsubstantiated. Certainly no ad hominem arguments. There has to be reasoned analysis based on whatever the relevant sources of authority are. So in constitutional law, you can interpret the Constitution, you can interpret Supreme Court precedents, and so forth. And one of the advantages of that approach, in addition to getting students to understand their own position better and to understand differing positions, is that the student is never identified with the particular argument they're making. with all due respect to them, I really don't care what their own ideas are, and I don't ask them what their own ideas are. That can be for their jam sessions with their friends afterwards. But what I care and what my professional responsibility training future lawyers is for them to be able, as I said, to articulate and advocate all plausible perspectives. So they could not pass my class without doing that. The next item on the list is referring to academic, quote, leaders, and I think did this come, I'm so sorry, my notes are blurry, whether this was from Betsy or from Randy. I'll give you both credit. Courage, conviction, and control, that's Betsy, right. I think where Randy comes into that is because his complimentary point that students have power. But Betsy, you're saying the professors should not cede that power, especially, and you alluded to this point, Betsy, because the students who are exercising that power may well be a minority, maybe even a minority of one, who therefore are depriving the rest of the students in the class of educational opportunities that they are seeking and they deserve. And I think too many professors, and I'll again attribute it to the best of motives, want to be kind and respectful, quite frankly, especially if the student identifies as some kind of traditionally oppressed minority. We want to be especially careful not to perpetuate that oppression. But I think we lose sight of that it is our responsibility to protect the other students who aren't speaking up from in effect being bullied and intimidated by the outspoken student. And I have many, many anecdotal examples from law students and other students around the country who talk about how a whole class has been ruined because of one student who will consistently be disruptive, and the professor is pandering to that one student, shortchanging all of the others. Here's one that is a double-edged sword, that recording what happens in class, obviously that might have a self-censoring impact, but it might protect against unjustified accusations. I think it's a complicated topic, but one that definitely warrants consideration and examination. And then I'm going to, Deborah in her talk mentioned that there ought to be a detailed free speech policy that spells out consequences for violating or engaging in free speech or speech that's not protected. I think that could be an especially important policy at a law school and an especially important educational experience to have students and student groups participate in negotiation and debating about what the details of that policy could be, and using specific, we don't even need hypotheticals, specific examples that have occurred on campuses around the country, at law schools around the country in particular, and debating how should that be handled. A lot of these are not clear-cut, and I think the devil is in the details, and it could be a very, enriching legal training experience to actually work on not only what the language of the policy should say in the abstract, but how it would apply in particular situations. And the last suggestion is actually, which came from the earlier panels, is actually one that I had planned on talking about myself before I came here, and so I will end with that and elaborate on it a little bit. It's been my mission for the past since 2015, when I started to understand that students with whom I otherwise had enormous agreement, those who were advocating for human rights and social justice, and in particular against unwarranted police abuse and even killing of unarmed black men. That's been a cause that I had been working on since before many of you were born in the 1980s. And I was very delighted that it was suddenly getting traction on college campuses for tragic reasons, because certain tragic killings had gotten a lot of media attention, thanks to social media, by the way, because we have to recognize the positive aspects of social media on all of these issues. But I became very concerned that these students, far from seeing freedom of speech as being their ally, as I had understood and experienced it to be, were, to the contrary, seeing it as somehow antithetical to their pro-human rights goals. So it has been my mission to explain why, I mean, no matter what your goals are, no matter what your political or policy preferences are, you need freedom of speech. But I felt that that understanding was particularly lacking to those on the left of the political spectrum. So that's been my mission, to point out to them how important it is. In this context, we have a special responsibility as law professors to explain to our students and to demonstrate to our students that no matter what they want to advocate in the legal profession, that it is absolutely an essential aspect of their professional training to listen to engage with, and to be able to articulate and advocate every plausible perspective on all issues. And in fact, until shockingly recently, that idea was absolutely so woven into the warp and woof of our law school cultures that there was even a kind of smugness on the part of law school professors and deans that, oh, you know, all of those controversies and shoutdowns and deplatformings that are happening at other parts of the university, including on our own university, that's never going to happen at a law school. So let me tell you, in July of 2017, Heather Gerken had just become the first female dean of the Harvard Law School, and she wrote a piece in Time magazine, which I read with great interest because it came out the day before I was going to testify in the Senate on campus free speech controversies and deplatformings. And she crowed with justifiable pride, but I'd say too much self-assurance that this would go on, that of all of these nasty speech suppressive incidents that were sweeping the country and prompting congressional hearings, none had happened at a law school. And somebody told me, well, maybe there was one incident at a law school before then, but to the best of my knowledge and my research, we didn't see that kind of incident at a law school until the next year. So it wasn't, it was fairly soon thereafter. She wrote this piece in the summer of 2017. In March of 2018, we had Christina Hoff Sommers being deplatformed at a law school in Portland, Oregon, Lewis and Clark Law School, and then we had Josh Blackman being shouted down at CUNY Law School in New York. And then I would say, there started to be a cascade of incidents at law school, which started out, for a while I was able to keep track of them on the fingers of one hand, and then sort of the floodgates let loose, and we know that even at Yale Law School itself, there have been horrendous incidents, including deplatforming of serious scholars and severe punishment of students for exercising free speech rights in 2022. So let me give you, from my experience at Yale Law School, using that as an example, why it is so important for students to be able to hear differing perspectives. After the deplatforming to which I referred occurred in 2022, when ironically Yale Law School was trying to illustrate the fact that lawyers who strongly disagree with each other on certain issues that are important to them can strongly agree with each other on other issues that are also important to them, and how that agreement can lead to collaboration, which makes it more likely that that shared perspective will actually prevail, whether it be in litigation or whether it be in legislation. It's something I certainly know from my ACLU experience. I worked hand in glove with people with whom I strongly disagreed on many important issues, but if in a particular situation we agreed and our collaboration meant that political doors would open or litigation doors would open that neither one of us could open on our own, that was wonderful. It was personally very enriching, too, to be able to develop relationships with people that I might not otherwise have encountered at an ACLU meeting, for example. So when the two people who were participating in this shouted down debate at Yale were Kristen Wagner, who is the legal director, and she's since become the CEO of Alliance Defending Freedom, ADF, and she was going to participate with a lawyer from the American Humanists Association, talking, interestingly enough, about a campus free speech issue, a very important one, where they had agreed and collaborated successfully in Supreme Court litigation. After that got shouted down, there was a great deal of pressure on the law school to make amends, including from federal judges who said, we're not going to hire Yale law students. So they wanted to restage the event. And for some reason, this time they invited me to be the liberal counterpart to Kristen Wagner. And I have to tell you that the students who came, it was not disrupted. I must admit, I was a little bit concerned as a free speech advocate. I thought maybe Yale Law School had gone too far in the other direction because there weren't even any peaceful, non-disruptive protests. But it was such an important learning experience. I won't go into the details, but I think students who came prepared to think that Kristen Wagner was a bigoted idiot who was winning all these Supreme Court cases because of biased conservative Supreme Court justices were blown away by the high caliber of her advocacy and also blown away by factual aspects of the case that really had not been described accurately in the media. And I will just make one point, which is that part of the reason why their most recent case won in the Supreme Court, 303 Creative versus Elenis, involving a website designer who did not want to provide certain messages with which she strongly disagreed to anybody. She did not discriminate on the basis of, or to use a more neutral term, she did not select her clients on the basis of who they were. But regardless of who you were, there were certain messages that she refused to design a website for, one of which, by the way, was any message that discriminated on any basis, including sexual orientation or gender identity. Most people don't know that. And what turned out, if you read the Supreme Court majority opinion, it becomes very clear. Facts that have made similar prior cases quite difficult, such as the so-called cake case, facts about, is this expression creative? Is it is it or is it seen reasonably as the expression of the website designer, or is she just seen as a conduit? All of those tricky issues in this case were non-issues because there was a stipulation of facts that Colorado had agreed to that basically gave away the whole case. I was stunned when I read that stipulation. And that came out during the panel, and along with some other litigation strategies that made it not surprising at all that Kristen's organization had won that case. And I remember a student at the back of the room raising his hand and saying, you know, what I've learned from this is that Colorado was really out-lawyered. And I thought, yeah, that is such an important lesson because so many students think they've got morality and justice on their side. They don't need to do more. They don't need to do the hard work of negotiating over factual stipulations. And Randy, if I can tell an anecdote that you've told so well about yourself, I'm thinking of the Dinesh D'Souza experience. that you talked about. I should start with the second one, where you did a great job, you felt, and you won, but that was because you did preparation. And the first one, this was a debate over affirmative action. You thought it was enough that you just had moral clarity and truth on your side, and you felt that you did not do justice to the cause. So we can motivate our students that if they want to be crusaders for social justice, racial justice, trans justice, you name whatever the cause is, it is for that reason, not despite that reason, that they must engage with and be able to articulate and advocate positions that they disagree with.
Thank you. We'll get some wisdom from Florida now.
Great. Thanks for having me. Thanks for arranging the technology to allow me to keep my commitment. Had this not been possible, I would have been with you because I made that commitment long before I accepted my role as a trustee at Florida Polytechnic University. I guess I'm a diversity pick for not having any STEM background whatsoever, but it's a neat institution, as I've been learning, and I'm definitely on an upward trajectory. So look, I have this book that's coming out about the illiberal takeover of legal education, the last part of which is devoted to what we do about it. And there are some things, both internal and external, I think, in terms of solutions. One is enforce the rules that we already have, right? This is a conference on free speech and civil discourse. Most, if not all, law schools have very clear, good rules and policies for what happens if someone disrupts a speaker event or interferes with a class or otherwise interferes with a university or student program. There are varying escalating levels of discipline, investigation, and all the rest of it. And if those are not applied, if those rules are not enforced, bad behavior will continue. What I found in researching these sorts of issues is that when university leaders all too rarely stand up to the mob and say, we're not doing this, we're not policing speech, and if you violate our rules against disruption, you will be punished, the mob disperses rather quickly. But all too many places, that's not happening. Number two, another thing that's fairly simple to implement, but unfortunately isn't happening in too many places, is that deans and other law school leaders are quite good at implementing, conveying, establishing whatever values they care about: public service, entrepreneurship, social justice, whatever they care about, whether it be through orientation, periodic deanly emails and memos, lectures from time to time, and events that are organized by the law school, by the dean's office, to model productive civil exchange or to cover topics that they think are important. Free speech, academic freedom, civil discourse should be at the top of that list. I've been speaking on this issue for a while now, since I had my lived experience, as it were, at Georgetown and at Hastings and all the rest of it. And deans come up to me from time to time. They're like, what can we do? And, it's not rocket science. Enforce your rules, instill a culture of free speech and open inquiry and civil discourse. And number three, I think there's a role for the admissions office. All too often, especially at elite schools, admissions offices have a bias towards activists as opposed to those who want to join a noble profession and believe in our institutions and the rule of law. If you self-select for activists, the people who want to change the world by any means necessary, you're going to get more activism. So I think tweaks need to be made in admissions processes. So those are internal things. And then there are exogenous shocks that I think are necessary, because I don't think we're going to get reform purely internally. So the boycotts at Yale and Stanford by Judges Ho and Branch and a dozen of their colleagues who have chosen not to name themselves publicly, I think is a good step. That shot across the bow, I think, is having an impact. It would have a greater impact if more judges joined, or even one justice. prospectively, not retrospectively. We're not engaging in punishment of existing students and whatnot. But Judge Ho says publicly that Yale students tell him, keep it going. And alumni, don't let up. It's working. Just because they hired Keith Whittington, just because Nadine and Kristen Wagoner came and did an event that went off very well, doesn't mean all of a sudden everything is hunky dory. It'll take a while to reform these structural pathologies at law schools, and employers not hiring people who shout at federal judges, "We hope your daughters are raped," or who celebrate the gang rape and beheading and other atrocities of Hamas. There are signals to be sent about what is required of joining the legal profession and being accepted in polite society. State legislatures have a role to play to defund and disestablish fonts of illiberal ideology like DEI offices and return to just the enforcement of federal civil rights and state civil rights laws and all the rest of it. And for that matter, it's not just DEI. The bureaucratization, this goes beyond law schools, but bureaucratization of higher ed and the relative loss of control by the faculty in favor of the non-teaching staffs has been a significant element in this dynamic towards the degradation of the freedom of speech and civil discourse. To get a little bit further in terms of academic freedom, free exchange of ideas, ending ideological discrimination in hiring, the Shills report. We talk about the Chicago trifecta, especially the freedom of speech principles, the Calvin report about institutional neutrality. The third part of that is the Shills report about not discriminating based on ideology when hiring. If that could be implemented, I think that would go a long way as well to improving the culture of free exchange at our law schools.
Thank you. Tom?
Great, thank you so much. In AG's overly generous introduction to me, I'm not sure he mentioned, he might have, that the most important thing, which is I'm the faculty director of something called the Chicago Forum on Free Inquiry and Expression, which is something that we launched, turns out, on October 6th with Nadine's help. It was a wonderful event. But that is a university-wide initiative committed to, as the name suggests, reestablishing the idea that the purpose of the university is free inquiry, and everything flows from that. Of course, free expression in universities, we use the term, but if you think about it, it's highly constrained. We always have constraints in universities about what you can say, right? I can't get up and lecture about nuclear physics in my law class for many reasons, but one of them is that it would be a violation of my obligations to my students and such. So putting free inquiry at the center and then trying to advance the understanding, practice, and protection of free expression. So that's a university-wide thing. Now, the reason I'm doing this is because, or the reason I assume I was asked, is because what we're initially doing is taking things that we do at the University of Chicago Law School and trying to generalize them across the university and maybe even across the country. And as Ilya has just said, University of Chicago Law School, or University of Chicago as an institution, has this kind of set of old principles, which I've learned recently date back to 1899, to the founding of the university, that we're really committed to free speech. And the university will not take positions on the issues of the day. That's not just Calvin, that goes back to 1899. And in addition, he mentioned the Shills report, which is very important and doesn't get as much attention, but that's basically non-discrimination in hiring. And that is how we run our university to this day. It's still binding rules internally. And so, we have these kind of old documents. Now, what have we done concretely in the law school? And I would not say we're perfect, by the way. We have much improvement. I think we all do. We've heard all the challenges this morning, which were really challenges from the culture, right? These are things that none of us is able to be completely, independent of or autonomous from. But we have done some things which I think are very practical and might be useful in other places. So the first thing is that for the last few years, we have been orienting every incoming student to these principles. We give them the Chicago principles, we give them the Calvin report, the rules on protest, and then we give them kind of a scenario Russia, Ukraine is what we use this year, and kind of a hypothetical. And that's really great for law students because that's what they are going to be doing, taking general principles and trying to work through a concrete situation in terms of how you go about thinking about it. Should you discipline? Was this a violation of the rules? And it's obviously an ambiguous hypothetical. And since we've done that, we have not had a disruptive protest. We did have one a few years ago. And just to Ilya's point, when we did have one, it was Eugene Kantorovich, who you may know, Ilya, who was giving a talk, and the Students for Justice in Palestine came in and broke up his thing, wouldn't let him talk. Well, we had a university disciplinary process, and the student was expelled, very severe sanction. But that's what you need to do, so I'm agreeing with Ilya, in the event of a willful, egregious violation. But if you orient people and they know the rules in advance, you probably won't have any of those. So that's our experience. Orientations for everyone. Now I'm doing them for all incoming faculty in the university, and I'd like to do them for every administrator. They have to be context sensitive, but every administrator should at least be exposed to these principles. Second thing we're doing, we started a few years ago, I think we started this after the Trump election, was now they've been endowed by Martha Nussbaum, so they're called Nussbaum seminars. They are just small group lunch discussions where we have two faculty take opposite sides of a contentious issue, and we shy away from none of them. Israel, Palestine, abortion, we take very affirmative action. Someone's going to be generally pro, someone's going to be against, but it's not a debate. We then curate the students. The students have to apply to join these, and so you get a set of 12 students with very diverse views, and they have to listen. They watch the faculty respectfully disagree. And, the outcome is just not an agreement. We're not trying to have no side. It's not about winning or losing. It's about just getting the positions on the table. So we've been doing that, and I think that's been very successful. And, of course, we just do have a broader culture. Jeff Stone, who was mentioned, Randy mentioned this morning, we'll often debate our alumnus Adam Mortara, who was the lead lawyer for Students for Fair Admissions, talk very publicly, respectful disagreement. So we try to model that. The other thing we do is, of course, that the university doesn't take positions, as I mentioned before, but I've come to the view, and this did come up this morning, that really isn't enough. That, free speech implies absence of constraint, but what we actually have to do is to actively construct environments in which students can have the opportunity to talk with people that they disagree with. And it's not going to happen on its own in this culture. It is not. So that requires all of us to be thinking very proactively in terms of how we structure those things. And I hope that the forum will do it. I hope the law school will continue to do it. I want to talk about a couple of other things just that are law school specific that did not come up. Well, Betsy mentioned the sexual harassment class, how hard that is to teach now. Another general one, which every law student has to take, is criminal law, because most students coming in don't think there should be criminal law. And my colleague was just complaining to me like, man, I've never got such low teaching evaluations in my life. Everyone's teaching evaluations are falling in that class. Nothing to do with the quality of their teaching. It's that students hate the concept. I don't know how we deal with that, but that might be another orientation thing. Like maybe we need to have a national kind of set of things. You're going to learn this stuff because you want to be defending. You want to defend the unjustly accused, rapist, murderer. Well, you better know the law in order to do that. And so I think we have to more actively get in front of those uncomfortable subjects which are affecting all of us. Fear of recording. I mean, Nadine was I don't know if we should record or not. Recently, we've been recording since COVID, and we're continuing to record classes. And I was just talking with one of my relatively junior colleagues, tenured person. He said, oh my God, I hate this recording. I'm just afraid I'm going to slip up, and the students are going to cut the message and then put me up on Twitter. So the faculty are terrified. We're all terrified. The faculty are terrified of the students are terrified of the students. Everyone is terrified of being, put up on social media in a way that's out of context. So I tend to think that means less recording is better. Students, in fact, when I was just this week giving lectures on Israel and Palestine, because it's something I study. And so, give a lecture on the history, a lecture on the speech environment now. And in both cases, I said to all the students, no recording. Because they're so afraid of being doxxed for just a question they might ask. And so I think I tend to be against recording. I think we might need to look at internal rules on doxing. And I'm using doxing not in the technical term, in the sense of like, oh, this person I just saw, he had a free Palestine tweet. I'm going to now report that to his employer and get him fired. That's happening in our law schools. that's really destructive of community. How can you have to be around people who have different views, and again, it's up to us to try to sort of facilitate that. Let me just segue from that into the employment situation. Right now, students are really afraid. The chilling effect of employers withdrawing offers is really, really serious. And of course, no one has a right to a job at Wachtell Lipton. You know what I mean? No one has a right to a job at Milbank Tweed or whatever. Law firms are free to associate with who they want to. At the same time, I really think that the chilling effect has gone too far. There's obviously genuinely anti-Semitic stuff, which has been said. And in some cases, the people apologize immediately. My wife has a friend at the Art Institute of Chicago who did a very unfortunate tweet, was on the front page of the New York Post, imagine that, apologized immedely and personally to everyone they knew, was fired anyway. So the idea, I mean, again, it's kind of ironic that the liberal students who, who think that, no one should be judged by their worst day are now being subject to that same, first of all, they weren't very willing when the shoe was on the other foot, but now they're realizing that, you might be judged by your worst tweet, which means to me that probably we should do less Twitter, but that's not obviously a good thing. So
I wouldn't know anything about that, Tom.
yeah, exactly. Well, Ilya, don't say I didn't, haven't given you advice. I think so I disagree with Ilya, I think, on the employment stuff. I think we should, and we've had incidents where students have said unfortunate things before this, and we have found them jobs. I mean, again, you can't guarantee that you'll be able to do it, but I think it's on us to encourage them to speak mindfully and wisely. If they slip up, they should apologize immediately and profusely. And there are some cases where they're just ideologues, and that's not going to happen. But I think those are the chilling effect on the good speech has been so strong that, you just say, I want a ceasefire in Gaza. Boom, you're out. So that, I think, has gone too far. I also want to disagree a little bit with you, Ilya, on, although we agree on discipline, I really strongly think state legislative power is not helpful here. State legislative power, Governor DeSantis, best thing he's ever done is appoint you, as near as I can tell. Sorry to just put that on the table. But the idea that the state is going to help here, I think is wrong. Politicians aren't really interested in free environments and free inquiry on campus. Politicians are interested in scoring political points. That's their job. No problem with it. Let him, let people run on the culture wars. But I do think it really has a potential to dangerously undermine all academic freedom in ways that are going to ultimately hurt conservatives as well as liberals. Imagine a second Trump administration comes in and uses some of the same policies that Governor DeSantis has used. We're cutting off all federal money if you teach about race. Let's just say it went that far. I'm not saying that that's what the Governor DeSantis has done, but the Stop Woke Act, that kind of, wow, how can we teach about American law if we're not going to teach about race? You can't do it well. So I really think state power is dangerous, and I don't think we should go down that. Your fellow, graduate Judge Ho, has. I wonder about that strategy of judges boycotting entire schools, because I haven't talked to him about it, but it strikes me that the people you're punishing are the three conservatives actually at Stanford Law School, or the three conservatives at Yale, who might have all kinds of reasons to go to Yale that have nothing to do with ideology. People go to law school, some of you in the room, go to your local law school for family reasons, and there's lots of reasons you could go there. So I don't see why we should have a blanket punishment. I do think, obviously, no donor has to give money to any institution they disagree with, but I worry a little bit that those blanket policies might be overbroad. So those are my thoughts. I do think that it really is on us to have this conversation. So again, I'll just close by thanking Marshall and HE for calling it together. It's really important to focus on law schools and exactly what we can do in a concrete way. Thank you. Thank you.
Can I say one thing? Can I say one thing about the state legislature point? Because I think we have to louder.
No, I was saying I wanted to have comments from the panel. That's you.
Go ahead.
Okay. On the state legislature point, I think we have to differentiate between different kinds of insertions by the politicians. So I agree with Tom that the legislature should not be designing and approving course syllabi or classes that can and can't be taught, or which words can and can't be said in class. That's not appropriate. But they, after all, for public institutions at least, are funding the various offices and programs and things like that. So they have a role to play in auditing and reviewing, whether we actually do need 59 assistant deputy deans for whatever, whether it's a DEI point, whether it's a something else point that's waste. I think there's a role to be played there. And I didn't mention this, and we haven't gotten to this, but the role for Congress, and this goes more broadly than for state schools because of Title VI funding, federal funding, there's all sorts of strings that are already attached to federal funding, ranging from maintaining accounting standards to abiding by anti-discrimination law. Well, there can be free speech compliance strings attached as well. I mean, I think all of that federal involvement in education is unconstitutional. But until we get to that promised land, I think we should, add classically liberal strings along with the technocratic ones.
Can I add just one tiniest rebuttal? I mean, just to respond. I agree with you on the free speech policy. I would just say on the state power, I'm from California. I got 3 degrees from the University of California, which was one of the greatest universities in the history of the world. And that the state power in that environment is going to look very different than in Florida. So I just want to point that out.
I would just add generally on a couple of these major issues, including employer boycotts, judge boycotts, as well as state legislation. I would say these are complicated binary issues and the devil is in the details. I agree that there are some pieces of legislation that could be positive, but they might be quite different from what has been endorsed here, because I get nervous when you talk about protecting free speech. That is such a contested concept. Even if we agree on the principle, applying it is so fact-specific. I would be very loath to turn over to a federal bureaucrat determining, when does peaceful protest cross the line to disruptive protest. I have less distrust for campus administrators than for those in the state legislature, but I'm a big fan of the Leonard Law in California that applies constitutional First Amendment standards to private institutions, except for religious institutions. Other people may disagree with that. In terms of the employment situation, I think it is very, very complicated. And I have a piece coming out in Time magazine about this, which is twice as long as we had originally thought it would be, precisely because we had to go into all of the relevant details. Take the 34 student groups at Harvard that signed on to what I consider to be a very anti-Semitic, very unfortunate statement. I still would oppose categorically denying a job to any student who belonged to one of those organizations. Because again, the devil is in the details. Students might not have known that the organization of which they're a member signed on to that statement. They may well have not seen the statement in advance. After they saw the statement, they might well have dissociated themselves from it or from the organization. So I see that more as an opportunity to engage with the student. Certainly, since my underlying goal is always dealing with hatred or anti-Semitism, Islamophobia, any kind of hatred, to try to change attitudes. I don't think punitive approaches are going to be helpful. I would like a more educational intervention. And so, of course, law firms probably have the right not to hire, but I would urge them, if they want to be part of this process of creating a culture of robust, civil, free speech kinds of discourse, which are so important in the legal profession, that perhaps the more constructive approach, at least in many situations, is dialogue with the student rather than categorically refusing to hire the student. But let me tell you, this may be old news to all of you, but I was so shocked when news first came out. I think the first example was the NYU law student who had an actual job withdrawn. One of my best friends is married to a hiring partner at a very major Wall Street firm, and she said he's constantly receiving anonymous emails that are reporting to him about tweets and other alleged infractions that have been made, including long ago, by various applicants to the firm. Some of you are nodding. Apparently, this has been going on for quite a while. So we're creating this surveillance snitch kind of society. I don't know what law firms' policy is, whether, I assume they do their own social media investigation, but this was a very troublesome realization for me.
I believe there was a circuit court case in the early 60s when a person lost his job because of a state law making the membership in the Communist Party illegal, which pointed out that students sometimes join the Communist Party to meet girls. So you have to, that in and of itself wasn't enough.
In a law school setting, I do have to speak on behalf of my colleague and friend Eugene Volokh, who has written for years now, including a detailed law review article. More recently, he's put it out in opinion pieces, that there are state laws and local laws that at least arguably might make it illegal to refuse to hire somebody or to retract a job because of expression on a political issue. So a professor at Stanford, I believe was the law school, wrote a Wall Street Journal op-eds urging employers not to hire students who had engaged in what he saw as anti-Semitic expression. And Eugene wrote a column in which he said, that can actually be legal malpractice. You have to look at what the law is. California has apparently interpreted its law on point very broadly in a way that could extend to the kinds of expression that are being targeted now.
Any other comments within the panel? Then we'll turn to the audience, and of course, we will start with Randall Kennedy, who can show us where we're all wrong.
Wonderful panel, but I want to push back against a comment made by my good friend Nadine Strossen. And what I want to push back on is your embrace of that California statute that imposes on institutions of higher education requirement to abide by First Amendment standards.
We've been debating this since the law was proposed.
Yes, we've been around this, right? Not lately. What about the claims of pluralism?
Yeah.
Imagine a small, imagine a college that says, we believe in laissez-faire economics and we don't want to hear from somebody else. Or the flip, we're a Maoist outfit and we don't want to hear from somebody else. In a nation this large, why not let 1,000 flowers bloom?
I think that's a very good point, and I'd probably be willing to cede it to you after all of these years.
Michelle, something quickly. Other questions? Way in the back. Ma'am?
Ma'am.
Sir.
So I think I'm kind of being stretched in all directions by all you distinguished ladies and gentlemen, and I guess where I'm really stuck is that I think the underlying conflict seems to be, on one hand, we want people to have the moral fiber, to have that courage, conviction, and exercise that control. On the other hand, we recognize that professors, administrators, students are just regular human beings who act upon incentives. Like, for example, I want to get tenure, or I need to bring in the college funding, or I get calls from students saying I want Shapiro set for what he said to Ketanji Brown Jackson, something like that. And because of that, like, on one hand, I agree that we should develop a culture. On the other hand, we have to do something about these incentives. And then I also fall back on, well, I share Professor Ginsburg's skepticism about using state power, because I think it's very coercive, and I think ultimately can lead to a little bit of hypocrisy. Essentially, I guess, to analogize it, using war to end all wars, so to speak. So I guess how do we get to a solution that allows us to, one, develop that culture, but also recognize that we are flawed human beings who are not going to necessarily, I guess, always live up to those ideals, and also just minimize the incentives that would cause us to stray. from them.
Yes. You know, we talk a lot about culture, but of course, culture is almost by definition something you can't manipulate and create overnight. And, you know, I feel lucky to be in an institution that's been kind of working on this for 130 years. It makes it a lot easier. You know, I think leaders do really matter, right? Leaders matter because they can tell the administrators, who has come up over and over again, are really the front line of this. I mean, students, of course, are going to complain. Students are going to demonstrate. Students are going to do what students do. It's the administrators which encourage that process, in some cases that we heard about with Stanford, or otherwise, you know, just fail to protect the shy, the quiet, those who are unsure, you know, from the sort of bullying that goes on. So, you know, ultimately you need administrative leaders to do that, but it isn't easy. I don't think we should pretend that culture is really easy. It's the only thing that works, but it isn't easy. So, you know, the only way I could generically say what schools ought to do, adopt some principles. I think we're going to have a lot of Calvin reports in the next 6 months. Suddenly, you know, no one liked it 3 months ago, and now everyone likes the Calvin report. Keith has a book coming out on it. Principles are important. Trainings, just getting people to talk about the issues, and then modeling that you can have respectful disagreement. But that's not easy. I just don't think we can pretend it's easy.
Yeah, and I think the training has to be the kind of role play training that remarkably you're doing for students. That has to be done for faculty members as well. How do you handle a concrete situation where you have a student saying X? In some way, Randy, you modeled that this morning when you were responding to a student who expressed emotional trauma. I mean, I think it would be really important for each of us to go through, maybe together with colleagues who can give us constructive criticism on how we could do a better job in those fraught situations.
Any questions more? As a bottom line.
I want to push back on the Calvin principle. So it has, as you say, become hugely popular, and at Harvard, it's like everybody seems to be saying this is the solution, or at least we don't get into as much trouble if only academic institutions wouldn't take these positions. And again, as the activist misfit really doesn't know what I'm doing in academia or what, I always felt like academic institutions had an important role to play. For example, in autocratic dictator regimes, because they have this free speech tradition, they have a little bit of more respect than other institutions often do, and maybe they're going to be freer to speak up against the regime than others. And again, I'm also not good at history, so who knows, but that's what I had thought, and I still feel it. I feel as if there's a leadership role for academic institutions to play that would involve speech, and they should be free to speak, even though they shouldn't be speaking for everybody who belongs to the institution. So tell me why that's
Great.
Before you do that, Tom, Marshall has asked me to briefly describe what the Calvin principles are. They were adopted in 1967 by the University of Chicago, and then kind of lapsed into lack of knowledge or discussion, recently have been resurrected. But basically, it is a policy that calls for institutional neutrality on contested public policy issues of the day, that the university qua university and constituent units such as departments within the university should only address issues that directly affect the university itself. So, for example, legislative attacks on academic freedom. The reason that is stated for the policy, and I support it for that reason, is precisely to empower constituent members of the university community freely to express their own views without the chill of fearing that they're disagreeing with the university's approved position. So I think really importantly, the principles state that this is not because we think these issues are unimportant or we're callous or we're indifferent. It's precisely because the issues are so important. We want to bend over backwards to empower every single member of this community to express their view on it.
Yeah, that's great. Very well stated. And so then the question is, what's the exception? And there is an exception. And I always say when I talk about it that the exception drafted in 1967 wasn't very well drafted. I'd encourage, if Harvard's going to adopt something like this, think it through. But clearly there are times, and this is what the report says, when the existence of the university, when its ability to function as a university is under threat. And then not only can the university speak, it must speak. The one recent example on which there was consensus was when the Trump administration passed the immigration restrictions. And we couldn't get students back from, to campus. We couldn't hire faculty from around the world. So President Zimmer spoke up, and that was not particularly controversial. Other times our leaders have strayed, and in a couple of cases in recent years have done the same statements that every other university has done. And those get criticized internally. So there's kind of a culture of enforcement, but there are really important exceptions. Now you bring up the example of most interest to me because I study the rest of the world generally, right? So one of the reasons I'm doing this work, because I think you can't really have free societies without free universities. And we've seen in many places, Hungary and China and Hong Kong, how vulnerable universities are. So then the question is, in those circumstances, what is the proper balance between the institution and its faculty? I think the Calvin theory, or the University of Chicago theory, going back to the 1890s, is that the university keeps quiet as an institution, and we absolutely protect every individual member of the community to say whatever they want. And so it's our individual selves which speak up for democracy, and we can't be fired. Now, in many other university systems, they don't have the autonomy of rich private universities that we have in this country. The state is the employer. They're subject to all kinds of things. And so that's a harder thing to maintain. But the idea of academic freedom, in a way, becomes the shield there. Yes, Viktor Orban, I know you want to fire this professor who's been criticizing you, but we have the norm of academic freedom. The university lets its people do whatever we want, and we keep our mouths shut. That balance might work in those places, but it's fairly contextual.
If I can add one thing, is that the importance of the Calvin report is that it prevents Calvin ball, right? If to coin a phrase, right? The cartoon where the rules constantly change based on the situation that the 6-year-old Calvin and Hobbes finds himself in, and a lot of universities now are having their coming to Jesus moment about the Calvin report about institutional neutrality, because they've issued statements on every minor piece of news in the last 6 years, and all of a sudden, what do you do about Israel-Hamas, which is a bigger deal than anything else, and now they're like, okay, we're going to be silent. So this does, in addition to the academic freedom promotion of individual students and faculty, which my colleague on the Florida Poly board, Dorian Abbott, geology professor at University of Chicago, was the beneficiary of as well, when the late President Bob Zimmer said that no, he's free to criticize university policy. That's fine. It helps that, but it also gets university leaders and law school leaders in our context out of having to play these games of, do I need to issue a statement on this, get pressured from both sides, what kind of statement, makes the job much harder. So if you just say hands off, that's for you to debate out and have your open inquiry about, but we as an institution, and I agree that there could be some need to fine tune that exception about having a real institutional interest about in an issue, but it made a whole lot of sense to me.
One of my favorite lines in the report, which is admirably concise, it's an excellent read. I guess I disagree with you. I think it's quite extraordinarily well written. Obviously, everything can be improved. But at the very end, it talks about, I think a point not only of principle, but of practical concern. Wouldn't we rather have the president of Harvard, my alma mater, doing more than just issuing? I've lost track of the number of statements that she's issued now, and each one generates more petitions for more different statements or amendments to the statement. That's not her expertise. And the Calvin report ends, my paraphrase isn't going to do it justice, but something like, universities should do what they do best and what only they are uniquely positioned to do. They should not waste their time being second-rate politicians.
I have this.
One small question. In the late 1930s, Harvard had, I don't know if it's 300 or 350th year celebration, and big wig academics from all over the world came, and they invited the chancellor of various universities in the Third Reich, many of whom were, well, you had to be intimately connected to the Nazi regime at that point. Now and Harvard had them speak and honored, blah, blah, blah. Would you consider that an application of the Calvin principle?
You mean inviting them to the conference?
Because they're neutral. They invited people from France, they invited people from Ecuador, they invited people from Britain.
I mean, I strongly believe that we have a cosmopolitan community of scholars, which is one of the reasons I oppose the BDS movement, which says, we're going to boycott Israeli institutions and no other country. I travel to China. Obviously, people in those countries are limited in what they can say, but the Calvin analysis would be the university doesn't invite anybody. Individual scholars do, and the university is just the host of those scholars and institutes. So if a scholar wanted to invite a Nazi, they'd be allowed to. Free speech for anti-Semites too. Richard Spencer was invited to Texas A&M, and Michael Young, the president, had to do some really creative administering, but Richard Spencer got to speak. That's how it works. So it's helped by a vision that the university is not responsible. Now, you sometimes hear from the critics, oh, but the university is providing a space and some of our tuition money is going to this speaker. And so the university is responsible for every speaker that gets invited. But if you think about that, it's a completely unworkable model. It means not only does the university president have to spend all their time chained to a desk in the basement writing bland statements, but they also have to be looking at lists of every invited speaker to see whether they endorse the view or not. It's not how a university operates.
Any other questions? We'll take the last question.
How does the Calvin principle doctrine, whatever it's called, apply to university presses publishing works that may be considered controversial, anti-Semitic? Marshall used the term white supremacist earlier. It comes to mind for me a few years ago during the pandemic, Marshall DeRosa, a politics professor at Florida Atlantic University, who's done extensive research on the Constitution of the Southern Confederacy, probably the expert on that, was shouted down at an administrative meeting by a student who said, you're not allowed to have a wrong opinion. I'm not going to get into that, but he then told me on the phone that his monograph on the Confederate Constitution, most recent publication since 1930, which had been published by the University of Missouri, could not get republished by an academic press because that was making a statement of endorsing ostensibly white supremacist document of political literature.
Yeah. This is the kind of psychology which says we should remove all the copies of Mein Kampf from the library, and anyone caught reading one should be doxxed and such. So, look, academic freedom technically applies to academics, academic research, professors, students. The freedom of learning is a part of it since the 19th century. And it doesn't apply to administrators. And so we sometimes get complaints because administrators want to do a Black Lives Matter statement at some peripheral part of the university, and we said, no, you just can't do it. So does it apply to the press? Well, I think thinking through logically what we're trying to do, it should apply to the press, and the press is making decisions with the faculty board that should be free from certainly administrative censorship by the center. But what we're facing, and this is the sub-theme of everything that we've been talking about today, is censorship not so much from institutions or even the state, it's from society deciding that, if you, the press, do this, we're going to punish you in some way. And that's the moment we're in, and that's what, hopeful that the fever will break, but without it, where is inquiry? I want to add one thing on this, which is I've just published a book as part of the launch of the Forum on Free Inquiry and Expression, a little book containing all these Chicago statements and a historical essay situation. If anyone wants one, just write me.
I highly recommend it, because it's got wonderful introductory material by you and Tony, right, in addition to the documents. And I, for one, had never heard of the Shills Report until the last year. It's very, very interesting reading, especially timely after October 7th. So yeah, I'm giving you an oral blurb for the book.
Final comment from the panel? Ilya? Anyone?
I have one final comment, which is, although we are appropriately focusing on law school, because the challenge is a cultural one, we keep stressing that point, we have to start a lot earlier. We really do have to start with K through 12 and those who educate them. And it is never too early to educate people in the nature of and importance of free speech principles and academic freedom principles, so that they will arrive at law school already acculturated in that direction.
Thank you.
Yeah, that's why it's unfortunate that, you see all these polls where the younger generations don't approach free speech the same way as previous generations. I don't know if they're going to grow out of that. They don't seem to be growing out of other illiberal things. But that's why when you're talking about law school, some of this might have to be remedial, because indeed, if the students had gotten this kind of acculturation in K-12 or undergrad, then the shout downs and other symptoms of these certain anti-speech pathologies wouldn't have reached law schools in the first place.
Thank you. It's time now for the vaunted coffee break. Well, you need to treat it as like a fast food. Fast food.